I want to thank all of you for attending the hrsimple.com webinar series. This is Eric from hrsimple again, and we're happy to present today's webinar, The New Exemption Regulations, Coming Soon to Your Workplace, brought to you by Ogletree Deakins, authoring firm of 4 publications on hrsimple.com. A few quick announcements. Today's presentation will last approximately 60 minutes with some extra time for Q&A at the end. We'll provide a SHRM event ID at the end of this webinar, which is worth 1 PDC. We encourage you to enter your questions in the chat box, and we'll address them when we can. We'll email you a copy of the recording and slides from this presentation afterwards. We're also posting all of our webinars at youtube.com/hrsimple. We have 2 great speakers from Ogletree Deakins today. And before they start, Paula from hrsimple is going to tell us more about them.
Stephen Pockrass practices in Indianapolis, Indiana, and is co-chair of the firm's Wage and Hour Practice Group. Throughout his career, Steve has devoted significant attention to advising employers on medical leave, accommodation, and related issues under the Family and Medical Leave Act, the Americans with Disabilities Act, the Indiana Workers' Compensation Act, and other federal and state laws. In addition to representing employers in lawsuits and administrative matters arising out of these leave-related laws, he has extensive experience defending against claims and lawsuits involving allegations of employment discrimination, harassment, and retaliation under Title VII of the Civil Rights Act of 1964 and the Age Discrimination in Employment Act. He's also recognized as an Indiana super lawyer in 2010, 2011, 2012, 2013, and 2014, and was named to Best Lawyers in 2013, 2014, and 2015. He is a member of the American Bar Association section of Labor and Employment Laws, Fair Labor Standards Legislation Committee. Our other speaker today is Chuck McDonald, who practices in Greenville, South Carolina. He practices primarily in the area of employment litigation. He was certified as a specialist in employment and labor law by the Supreme Court of South Carolina in 2006. Over the past 19 years, he has represented clients in all aspects of employment litigation, including race, sex, age, and disability lawsuits, retaliation, breach of employment contract cases, general contract actions, non-compete cases, and wage and hour cases. He regularly represents clients in the manufacturing, healthcare, and services industry. He also represents a number of governmental agencies. He is admitted to practice in the state of South Carolina, 1995, the U.S. District Court for the District of South Carolina, 1997, and the U.S. Court of Appeals for the 4th Circuit, 1999. He litigates all aspects of employment law cases in state and federal courts, drafts employment contracts, severance agreements, and non-compete agreements. He also drafts and reviews policy and procedure manuals and employee handbooks. Chuck also provides harassment training, performs human resource audits, and audits employers' timekeeping and payroll practices. He has been recognized as a South Carolina super lawyer from 2009 to 2015, named to Best Lawyers in America in 2013, 2014, and 2015.
Thanks, Paula. All right, let's get started. Chuck, you have the floor.
Thank you very much. Good afternoon, except for maybe some of you in the West Coast, and good morning to y'all. Today we're going to talk about the proposed regulations to change the salary amount for exempt employees under the Fair Labor Standards Act. Before we get too far into it, I want to talk a little bit and very briefly, because I know we don't have a lot of time, about currently what the law is and where we're heading and what we're seeing. If you'll recall, currently there's 3 tests that employees must meet in order to be exempt from the overtime requirements of the FLSA. They must meet the salary test, they must meet the salary amount, and they must meet the primary duty test. Currently, the salary amount is $455 a week, which equates to $23,660 a year annually. They must be paid that guaranteed salary each week except for recognized deductions, and that's a different topic we won't get into today. But basically, they got to get that guaranteed salary regardless of the hours they work. And then they have to meet the primary duty test. The regulations that have been proposed and that we're going to talk about today focus on increasing the salary amount, and there are also some comments and discussions about the primary duties and whether those primary duties should be amended or changed, and Steve will spend some time talking about that as we go through the program. So again, what kind of environment are we dealing with, and where are we getting? First of all, I think it's interesting. If you look at a blog post from Wage and Hour Investigator Wheel from November 5th, 2014, I think gives some insight to where the Department of Labor is from an enforcement standpoint. One of the quotes from his blog post was, "The industries where workers are most likely to be mistakenly or deliberately cheated out of wages." I think it's important that when you see the term cheated out of wages, you get a sense from where the Department of Labor is coming from. They still feel like most employers, or a lot of employers out there, are not following the wage and hour laws, and the DOL is out there trying to police employers to ensure compliance with various minimum wage and overtime requirements. So that's sort of the backdrop we have. He also indicated that investigations of one employer resonate throughout that industry, and making examples of employers throughout a particular industry. For those of y'all who deal with a lot or have had wage and hour audits, most of those usually come from a complaint from an employee, but also each year the Department of Labor in Washington picks certain industries that they're going to target for audits to ensure compliance with the wage and hour laws. So again, this is sort of the mindset we're coming from. The whole thing really originated from a memorandum from President Obama on March 13, 2014. In it, he basically told the DOL it was time to modernize and streamline the FLSA regulations. Just so you'll understand, the Department of Labor has the authority to issue regulations interpreting laws, including the minimum wage and overtime laws in the FLSA. So that was a directive from President Obama to look at the current regulations and make improvements to update them. And what's interesting, if you look at the 3 bullet points, update existing protections, which clearly these new proposed regs do, to simplify the regulations, which to some extent these new proposed regulations might do, and then address the changing nature of the workplace. Personally, I'm not sure how much they really did to change the nature of the workplace into what I would call the technology world we live in today, but most of this has been focused on the salary and the amount of money. Okay, so how does all this work? What you basically start with is Department of Labor cannot just make substantial revisions to its regulations without giving the public an opportunity to hear the changes, to make comments on those changes, and to then have final rules in a time period before those rules become effective from a legal standpoint. We are currently in the proposed comment period, or in the comment period for the proposed regulations. The regs were published officially in the Federal Register on July 6th. The public comment period is scheduled to end September 4th. We don't have any indication that might be extended. It could, but there's no guarantee that it has to be. So this is the opportunity now for any employer out there. You can get your trade association, your Chamber of Commerce. Anybody can write in a public comment either electronically through the DOL website, or you can write a letter to the Department of Labor giving your input and feelings on the proposed regulations, changes to the FLSA regulations. What is interesting is if you look back at the last time these regulations were substantially changed, which was 2004, you will see that the comment period lasted about the same amount of time it has in this period. But when you look at the time the proposed regs were published and the time the rules were actually finalized, it was about a 14-month period. So for those of y'all who are trying to figure out when are these likely to go into effect if they are passed, my guess is it will be sometime in the summer of 2016. Because 2016 is an election year, you can be guaranteed something's going to come out before we get too deep into the election campaign. But historically, if you look back at 2004, a 13, 14-month time period is probably about as quick as you can get. And the reason is the Department of Labor is required to read all the comments they receive. In 2004, they received 75,000 comments. So if they get anything close to that, this go-around, we would expect anywhere from a 12 to 14-month period before you'd see these regulations become final. Okay. So what is the proposed reg, and how did we get here? What the proposal basically is to increase the salary amount from $23,660 to a figure that by 2016 will likely be around $50,440. And how the Department of Labor got there is that they looked at data that's published by the Census Bureau, looking at looking at the salary pay of both exempt and non-exempt employees, but people who are paid on a salary basis throughout the country, and they are looking at this $50,440 or the $970 as the 40th percentile. So if you take everybody in America who's being paid on a salary basis, a guaranteed salary, the 40th percentile of that would be $970 is what is projected to be as of summer of 2016. Currently, when these regs were published, it would be $921 or $47,892. How we got here was in 2004 when you did the revisions to the regulations. We used to have a short test and a long test for the primary duty, and each test had a different salary. In 2004, they did away with the long and short primary duty test, but they and created just one test, the primary duty test, and then created one salary level. What the Department of Labor is saying today in these proposed regs is that in 2004 they created a primary duty test, which was, in their opinion, the easier duty test to meet, but they used a lower salary threshold instead of a higher salary threshold. Their proposal is to raise that salary threshold to the 40th percentile of people in America who are being paid by a guaranteed salary. They believe that will put it more in line with wages to be paid of an exempt employee in 2015. The other thing they repeatedly talk about in these proposed regulations is that the best test for establishing exempt status is the salary test. So in the proposed regs, and Steve will talk about this in a little bit, there's not a proposal to change the primary duty test at this time, but they have indicated that they would like comments on whether or not the primary duty test needs to be changed. We don't know whether in the final regs there could be some change to the primary duty, but when you read the regulations, the sense you get is the Department of Labor feels by increasing this minimum salary level to almost $50,000 a year, that this is going to take care of the, for lack of a better word, easier primary duty test, and that this proposed salary increase along with the current primary duty test would be a good indication of whether someone is an exempt employee. The Department of Labor projects that this impact could have as high as $592 million impact in year one on employees and wages. Whether it becomes that high will depend on how employers react to this, whether they reclassify employees, whether they bump existing employees' pay up to meet the minimum threshold for the salary level for exempt status. But clearly this is going to have an impact on businesses throughout the country because you're talking about an increase of 50%. And like I said, there will be some time period, probably 60 to 90 days, once the regs become final before they will be implemented as far as will be enforced by the Department of Labor. But you can estimate that that's going to be somewhere in the summer of 2016. So again, for budgeting purposes, I do think it's time to look at your workforce to see how this is going to impact you and anticipate that there is definitely going to be some change with the salary level by 2016 for your exempt employees. The DOL also incorporates a plan for an automatic adjustment to this salary level. One of the concerns the Department of Labor has is in order for them to change the salary level, they'd have to come back through the comment period and go and receive comments from the public to then revise the regulations. They're anticipating doing an automatic increase that would be based either on the Consumer Price Index or an annual review of what the 40th percentile of wages are in America for people being paid on a salary basis. The Department of Labor looked at this in 2004 but did not implement it. Based on the fact that they didn't implement it in 2004 and it's now been almost 10 years without a change in the salary level, I can almost guarantee you that there's going to be some component of some automatic update, whether it be annually or every couple of years or 3 years. There's going to be something that is going to create a situation where you have an automatic update, because I don't think Department of Labor is going to let itself get in a position again where they don't have the ability to try to keep that salary level consistent with employees' pay throughout the country. So again, some people have asked in other speeches and webinars I've done whether they think the Consumer Price Index or the 40 percentile is better. Again, I don't really know. It's difficult. I wouldn't be surprised if some economists don't write some papers soon to talk about this and which one may have a bigger impact than others. All I do know is obviously it won't be a 50% increase like we're seeing with these current proposed regs, but it does mean that if you have someone making $46,000 a year right now and you're going to stretch to get them to 50, don't think that it'll be 50 for the next 2 or 3 or 4 years. I think it'll be 50, and then it may go up $1,000, $1,500, $1,800 each year, depending on what happens with the 40th percentile or the Consumer Price Index. I've also had in a couple of speeches I've done a number of clients who have asked, well, what if the Consumer Price Index goes down? If it goes down, I think you'll find the salary basis will remain flat. I don't think there's any way Department of Labor is going to take it down. I could be wrong, but that's my experience is it would just remain flat. Currently, there's also the highly compensated employee exemption. I don't know how familiar people on this call are with it, but it was created in 2004, and the goal of that was to say if an employee made $100,000 a year, then they met one of the primary duty factors. Each exemption has multiple primary duty factors. If they met one of the primary duty factors for the exemption and also were paid $100,000 a year, then they would be exempt under the highly compensated employee exemption. What these proposed regs also look to do is increase the highly compensated employee salary minimum level. Like we said earlier with the proposed regulations, that salary amount for other exempt employees would be at 40 percentile. The highly compensated employee is proposed to be at the 90th percentile, which currently would be $122,148 a year. They're also proposing to have some kind of automatic update annually for the highly compensated employee minimum salary exemption as well. So that's what the proposal is. That's kind of how we've gotten there. But you'll still have to meet the test for the highly compensated employee and the minimum duties if you want to qualify for the highly compensated employee. But at this time, there's no changes to that exemption other than increasing the minimum salary. And with that in mind, I'm going to go ahead and turn it over to Steve, who's going to talk about a couple of other components and talk about the primary duties element of these proposed regs. Steve?
Thanks, Chuck. So the next thing that we're going to talk about is, as Chuck mentioned, the proposal with regard to the salary is to raise it to the 40th percentile, which would more than double the minimum salary requirement from the $23,660 to what's projected to be $50,440. And a salary is a guaranteed amount that's paid on a weekly basis or a monthly basis, or maybe you pay every the middle of the month and the end of the month, or you pay every 2 weeks. But it's this guaranteed amount that is not subject to deductions regardless of the quantity or the quality of the work, except with certain exceptions. So we're starting with a rule where we used to say, or we're currently saying, $455 per week that has to be the guaranteed amount that you pay in order to meet the salary requirement. Well, if we're going to more than double that, the Department of Labor is saying, should we consider other forms of compensation in addition to the salary or as part of the salary to help sort of ease that blow or that transition? And in certain industries, especially, say, retail and other industries, there are often, say, for example, monthly bonuses that are paid based upon store sales or company performance, or you've got a group of individuals who are salespeople who work under you, and part of your compensation is based upon their sales and their performance. And so the Department of Labor is considering adding or including in these numbers then some changes that would allow you to include some of that non-discretionary compensation toward the salary requirement. So the first question they're asking is, how much do we include? And they're saying that they're thinking about considering 10%. And so what we're saying then is it would be 10% of the total salary, or up to 10% of the total salary could be in the form of this non-discretionary compensation. So if we go to what Chuck had said about anticipating $970 per week being the minimum salary threshold, $97 of that could come from this non-discretionary compensation. Or if we look at it on an annualized basis, if we're saying that $50,440 is going to be the minimum salary to meet the salary requirement for the exemption, then you could have $5,044 coming from your non-discretionary bonuses. So you could have a salary of $45,396 plus this non-discretionary bonus amount of at least $5,044 that would get you over the threshold. Now, the question then becomes, well, what if you get bonuses, non-discretionary bonuses that are higher than that? Well, you would only be allowed to count that portion, so a smaller amount, toward the total salary. So they're looking at a 10% as what they consider to be sort of the maximum level. It's possible that they won't include any portion of discretionary bonuses or non-discretionary bonuses toward the salary level, or a smaller amount. Question that's just been asked is, what about contributions to retirement, toward health insurance, things like that? The Department of Labor has said that in calculating the salary, it is not inclined to include any sort of fringe benefits such as retirement contributions, value of health insurance, all of those other things that add a lot of cost to what you pay to your employees, both exempt and non-exempt, but especially if you have a good fringe benefit package for your salaried exempt employees. They are not planning to allow you to count any of that toward the minimum compensation level. Another question that they had, sorry, I flipped slides too quickly, is whether to limit the time period for that non-discretionary compensation. So here the point is this, is a lot of folks, say going back to the example of the store sales, that a portion of your compensation might be based upon the sales of a store that you oversee or manage, or maybe you're the director for 3 or 4 stores, and your compensation is based in part upon the performance of those 3 or 4 stores. A lot of times those payments are made on a monthly basis. But what if they're made every quarter or every 6 months or annual? The Department of Labor is saying that at most they would allow something paid on a monthly basis, or more frequently than that, to be counted toward the salary. So if you had a compensation plan that included non-discretionary bonuses that were paid every 3 months or every 6 months, you would not be allowed to include those as part of their calculation. And the reason for that being that they want to make sure that people are getting the minimum compensation in a relatively timely manner, and that if they have to wait 3 months or 6 months, that they consider that inconsistent with the idea of a regular salary.
Steve,
Another area where they're considering making changes. As Chuck noted, the current proposal does not make any actual changes to the job duties tests or the primary duty requirements for the various exemptions. And I think this was a bit of a surprise to all of us from the very beginning when President Obama had issued this directive to the Department of Labor back in March of 2014. The conventional wisdom was that the Department of Labor would include some sort of requirement that a certain percentage of an exempt employee's work would have to be exempt duties. And yet when they came out with the proposal, they said, well, we're considering it, we're thinking about it, but we haven't made any decisions, and so we'll solicit comments on it, and instead we're focusing just on or primarily on the minimum salary requirement. And I think people are concerned, employers are concerned for two reasons. One reason is that they feel like, well, if we then are told later that we do have some sort of a percentage requirement, we're really not getting very much notice. If that's part of the final rule, we didn't really get much of an opportunity to comment on this. The other concern is that by sort of structuring it in this way, employers may say, hey, look, we really, while we don't like the giant increase in the minimum salary, that's better than having some change in the job duties test. Or if they fight for a lower salary, that the outcome is going to be, in the final rule, would be a salary that's less than $50,000, but also imposes some job duties requirements. The proposal that they're talking about, or what they've asked for comments on, has to do with this quantitative definition. As Chuck talked about, there used to be the long test and the short test, and it used to be that you would look at how much of an exempt employee's work was truly exempt, not just sort of this idea of the primary duty, but how often were you doing that as part of your workday. So do you have to now have, or under a new rule, would you have to do at least 20% of your work? Would that have to be at least 20% of your work be exempt, 25% of your work? They've specifically said, should we look at California, where there is a 50% requirement that you need to perform in order to be exempt in California under California state wage and hour laws, at least 50% of your working time needs to be performing exempt work. And so that becomes a big challenge for California employers, both in terms of record keeping and in terms of litigation. And so, as Chuck mentioned, the whole idea, or an idea of this, was to streamline things and reduce the amount of litigation, and doing something like a California rule certainly would not be helpful in terms of understanding or trying to make this a simpler requirement for employers. So that's something else that we're keeping our eye on. Specifically, the Department of Labor has asked five questions with regard to the primary duties test. These are things that they're asking for comments on. As Chuck mentioned, we've got a time window through September 4th for employers to provide comments to the Department of Labor. And you can provide comments on any items you want, but they've identified certain topics on which they would like to receive comments, and these include the following 5 items with regard to the primary duties test. One is they're asking what changes to the duties test should be made, if any. Second, they've asked, should they establish a minimum amount of time an employee spends performing primary duties of exempt work? And so that's what we were just talking about with, should there be a 20%, 25%? Specifically, then the third question is, should we make use of California's primarily engaged in standard of 50%, that you've got to be primarily engaged in your primary duty at least 50% of the time. They've also asked, again, going back to the point that Chuck made earlier, is this single standard duties test that we have, as opposed to a long test and a short test, is that effective, or should we go back to having multiple tests? And if we did, then would we then have differing salary requirements under the two different tests? And then the last question is, does the concurrent duties regulation for exempt employees work, or should there be a limitation on the time spent performing non-exempt work? And the concurrent duties regulation basically says that just because you're performing non-exempt work at a certain point in time doesn't mean that you aren't also performing exempt work. And so the primary example would be the person who's the general manager at a fast food restaurant. And that person is they're an exempt executive who is overseeing a specific store. They're directing 2 or more employees. They are running the store, making sure that it operates effectively and provides good service. But at those peak periods when you've got a lot of customers in there, they may very well be running a cash register, making food, engaged in other activities while still running the store. So concurrently, they're doing things that would be viewed as non-exempt, like running the cash register or making food, but they're also still running the store. And so that's what they mean by concurrent duties. And when you're measuring how much time somebody is spending on exempt or non-exempt work, if you're looking at concurrent duties, then you'd say, well, that is still exempt work because they're still running the store. And so this question is, does the concurrent duties test make sense, or do they need to revamp that? So that's another question that the Department of Labor is asking. As I mentioned, comments are invited on other topics as well. And so while the Department of Labor is saying you can comment on anything you want, here are the things that we want comments on. And we would certainly encourage all of you to submit comments in response to the proposal. One area where they want comments is on the minimum salary level, and the question of should we set it at the 40th percentile? And there are a lot of commentators who have noted that here we're looking at 40th percentile of all salaried employees. So it's anybody who currently is being paid a salary or anybody who's currently being paid a salary, whether or not they're being treated as exempt right now. And it's not making any separations or taking into account regional variations, cost of living, things like that. It's just saying straight across the board, 40th percentile. And so that is certainly a concern. Another big concern, obviously, is the fact that we're more than doubling, under the proposal, we're more than doubling the minimum salary. And so while they may feel as though 40th percentile would be an appropriate number, the fact that they're getting there or trying to get there in a single jump as opposed to any sort of a staged or structured increase certainly is a problem for a lot of employers who, if you've got somebody who's at $30,000 right now, are you necessarily going to increase their salary by $20,000 in order to allow you to reach that minimum salary level? So they are asking about the salary level, I think both from a methodology standpoint, which is should they set it at the 40th percentile, as well as the raw numbers themselves. Second thing they're asking for comments on is the methodology for annual increases. And again, the question of if we set it at a certain percentile, should we then keep it at that percentile, 40th percentile for salaried employees and 90th percentile for highly compensated employees, or should we in fact make some other change or follow the CPIU so that it just goes up with the cost of living? I've always, I'd say always, but since the regulations have come out, have wondered what would happen in year 2 with regard to if they keep it at the 40th percentile and you're increasing the salaries of a lot of employees. I mean, basically you're going to take some salaried employees and make them hourly. Other salaried employees, you're going to increase their salaries to get it up to this $50,000 level. In year 2, won't the 40th percentile then end up being a lot higher than $50,000? And so, while I'm not necessarily a fan of the CPIU method, that is certainly one concern that I have is that the first year increase would cause the 40th percentile to be extremely high during the second year, and whereas the CPIU is going to change regardless, it's not going to be affected by these salary levels or shouldn't be affected by it. And generally in the past, both the 40th percentile and the CPIU have resulted in increases of about 2.6% per year. So if you're looking at what sort of percentage increases you may have for the annual increases, that would be historically at least what we've been looking at. The other thing to keep in mind or to comment on too is whether you think there should be annual increases, and if so, do they increase every January 1st? Should they increase July 1st, as Chuck said, as opposed to annual increases? Would it be better to have an increase that is every 2 years or 3 years? And then the other thing, too, is how much notice the employers are going to get before they have to make this increase. So, for example, right now what they're saying is they would plan to give employers 60 days notice of what the new salary level would be based upon the 40th percentile. And then you'd have those 60 days to make your adjustments, or would they say in January of 2017, effective January 2018, here's what the new minimum salary level would be. So something else that you want to comment on is how much advance notice you get. So, for example, we've got a question here, would they continue to use the 40th percentile going forward? That's exactly the question they're asking us to comment on, is should they use the 40th percentile going forward, or should they adjust it every year based upon the CPIU? So they're asking us, if they set it at the 40th percentile now, how should the annual increases be measured, what methodology, and should they be annual increases or should they be increased at some other variation, and how much notice do you get for those increases? They've also asked for comments on the non-discretionary bonuses, which we talked about. So here you're going to want to be commenting on, should the level be 10%? Should it be higher than 10%? Obviously from an employer's standpoint, you'd like to be able to include as much of those bonuses as you can, and you'd like to be able to use bonuses that are paid a month out, 3 months out, 6 months out. The challenge is going to be how, from a methodology standpoint, do you add those numbers in to the salaries if, in fact, it's going to take a month or 2 months or 3 months to know exactly what the individual's total compensation would be, and also what happens if you've got somebody who leaves in advance of getting a bonus that would put them over the salary level. So they're asking about comments on the non-discretionary bonuses. You certainly, as an employer, can suggest that the things that they say they don't want to include, things like the fringe benefits, retirement contributions, you can certainly suggest that that be counted toward the minimum salary requirement and provide those comments to establish the record for the proposals. They've also said that they don't intend to include commissions as part of the salary, and their logic behind that is that commissions usually are paid to salespeople who either are going to fall under the outside sales exemption, but assuming that they don't, that those commissions are for people who generally do not meet the job duties requirements. But it also depends on how you define what a commission is. And so you may want to comment on the fact that that really commissions are no different from bonuses in a lot of ways, and that they should be included in the salary requirements. The Department of Labor is also interested in industry-specific examples. So if you're in an industry where a lot of an individual's compensation does come from commissions, you may want to point that out. Or if you're in an industry where commissions and bonuses of a significant amount get paid at a certain time of year because you're more of a seasonal type of business, that would again be something to point out in your comments. The Department of Labor also has asked for comments on computer occupations that should be treated as exempt. We see a lot of problems where people identify, say, a computer help desk person as being an exempt employee, and the Department of Labor takes the position that those jobs are largely that they're not jobs that necessarily require discretion and independent judgment, and that while running a help desk or being a help desk assistant tends to be very valuable, oftentimes those individuals are working out of a manual. There are specific steps that are to be taken to address any specific problem, and that by working directly from the manual, that they are really not exercising discretion and independent judgment. And so the Department of Labor also has admitted, though, in its regulations that with the computer and IT businesses and professions changing so much and so quickly, they haven't necessarily been able to keep up with that. And so they want comments about how the computer occupations should be addressed in these proposed regulations as well. And again, any additional topics that you deem to be appropriate, for example, one of the ones that seems to me to be important is once the final rule is in place, how much time will be given before the new rule goes into effect. As Chuck mentioned previously, in 2004, they gave 4 months from the time the rule went into place to the time it becomes effective. Our concern would be that you'd want to have at least that much time, if not more, so that once you know what the final rule is, you're given adequate time to try to comply with that. So that would be another topic, for example, where you would want to provide comments. So how do you provide these comments? There are really 2 ways to do it. You can do it by mail or electronically. Doing it electronically is probably the simplest. We've provided the link to the website, www.regulations.gov, and that if you go to that website, you'll see a search box there, and if you type in 1235-AA11, that's what's called the RIN. It's a special number for each of the regulations. And so if you type that in there and then hit enter, it'll take you right to the Department of Labor proposal, and you can submit your comments electronically that way. It's really important when you do these to make sure that those comments are substantive and that you tailor your comments to your business or your industry so that, for example, if you are in retail or one of these industries that may be hard hit, that you point that out. They're particularly looking for comments from small businesses. So if you are from a small business, you ought to point that out in your comments and talk about the negative or adverse impact that some of these would, in fact, cause for you. You may, if for some reason you don't want to submit comments yourself, you may want to contact your trade association and ask them if they're submitting comments, submit comments through your trade association. And if you are a trade association, certainly solicit comments and feedback from your members and submit comments on behalf and talk about the number of members you represent and the types of businesses you represent, so that even though if it's a single trade association, that it reflects the views of a larger number of businesses. You can contact your local Chamber of Commerce to see whether they're going to be submitting comments, as well as to express your views and opinions. And we know, too, that people are contacting their members of Congress both to try to get additional time to respond to the regulations, as well as to talk about potential legal challenges once final regulations are put into place. So what can you do right now in addition to the comments? In other words, sort of here's where the rubber hits the road in terms of your internal actions. What sort of things can you do? One is you want to be compliant with the current overtime regulations. You know that currently the job duties test right now is supposedly not going to change, or they're soliciting comments on it about potential changes. But if you're not in compliance right now, you're certainly not going to be in compliance in the future. So this is a point to look at, are you in compliance under the current job duties requirements? Audit your existing classifications. I would always suggest that you work with your outside counsel to do that so that you can maximize to the greatest extent possible any attorney-client privilege in those communications. Evaluate your jobs that are most likely going to be impacted by the new regulations. So, for example, if you've got folks who all make over $60,000 a year and appear to be exempt right now, you're probably in good shape with all those people. If you've got people who are at 50,000 plus, you're probably in good shape with them as well, but you've got to be concerned about the fact that as the numbers go up, what are you going to do with those jobs and those positions? If you've got people who you're treating as exempt who are in the $25,000 to $35,000 categories, right now you've got to be thinking about, in that band, are we even going to try to make them exempt? And if not, how are we going to address those? So looking at the jobs, looking at what you're currently paying in those jobs, looking at the pay ranges for the jobs, you can sort of break out, especially by pay levels, which jobs most likely are going to need to, or are most likely going to be affected by the change in the regulations. So then the question becomes, what do you do with those people who are not who under the proposed regulations would not be treated as exempt. And if you're not going to raise their salaries to meet the $50,000 plus level, what are you going to do? How are you going to change their compensation to address the fact that they're now going to be non-exempt and subject to overtime? Well, one thing you could do is simply just still pay them the same salary and know, in fact, that any time they work over 40 hours, you're going to have to pay them overtime. But there's going to be an increased cost to that. So some employers are going to take the salary level and they're going to lower it based upon what they anticipate the overtime would be, so that at the end of the year, the person would still get the same total income, but it would be a combination of salary plus overtime on that. Some employers then are going to say, well, look, if we know that we're going to have to pay overtime, rather than trying to calculate overtime based upon a salary, which can be confusing, we'll just tell them the Department of Labor has changed the rules or is about to change the rules, and we're going to convert you to an hourly employee. Here's what your hourly rate will be, and you'll get time and a half in overtime based upon your hourly rate, and that way they can predict, and you can predict how much they will receive. And then, there are various other types of compensation plans that you can put into effect, but you're going to have to remember that whatever compensation plan you use, you're going to have to pay overtime to these individuals who are no longer exempt. Question here that we got was, wouldn't employees still have to meet not only the salary test as well as the duties test? We can't just raise the salary and call them exempt. That's correct. They'll still have to meet under the new regulations. However they come out, they'll still have to meet the salary requirements and the duties requirements under the new regulations. So if I gave you the impression that simply raising the salary would be enough, they still will need to meet the duties test. But the Department of Labor has, as Chuck said, basically said that salary is the best indication of what will be a truly exempt person. And so their feeling is, hey, if we raise the salary level to $50,000 a year, that employers are more likely to be complying with the requirements based upon the fact that the salary is as high as they're trying to set it. So you could, again, raise the salaries to meet the new minimum salary requirement, require them to meet the job duties requirement. You could also ask your exempt employees who you know are exempt to do a lot more work so that they are taking up some of the slack for people who you no longer want to be doing the same amount of work because you know that you'll have to pay them overtime. You could do some restructuring or resizing of your workforce, for example, hiring more employees who are part-time so that you try to avoid having to pay additional benefits, but also not putting them in a position where they would be likely to work any sort of overtime. And you also need to have a strategy for future years because, as we talked about, there are annual increases proposed. And so with that, let me turn it back over to Chuck to address a few additional items.
Thanks. Real quick, I saw a couple of questions. One I think we missed, which was dealing with teachers. And assuming that people are classified as a professional exempt teacher, these changes really wouldn't impact them because there's teachers, lawyers, and physicians are exempt from the salary requirement under the FLSA, so this should not impact teachers under the FLSA. I see a couple of other questions coming in. Is there anything on the horizon regarding other exemptions such as that for agriculture? Not that we know right now, and with everything going on and knowing that the minimum wage is going to be the next hot topic with the Department of Labor and an election year coming up, I would be just surprised to see anything in any other area of any other industry. If anything, it'll be a tweak, I think, to this primary duty test like Steve was mentioning. A couple things I wanted to point out that that I've had in other presentations that I've given is people have asked, what should we comment on? I do think that depends on your industry and your particular business. But what I would say is I think you need to be realistic with your comments and send comments that have a chance to have an impact. People have asked, what are your chances what are the chances these are going through? I think these clearly are going to go through. They're going to get passed. Currently, the Department of Labor says in the proposed regulations that the current poverty level for a family of four is $24,000. So the current exempt salary level for exempt employees is lower than the poverty level for a family of four nationally throughout the country. So, I think there's a clear indication that this salary level is going to go up. To me, the things I would concentrate on are, does there need to be an automatic, element to it? And even if there does need to be an automatic element, does it need to be every year? I don't see why it couldn't be every 2 years, every 3 years, or why another one is, okay, if you're going to use the 40th percentile, does it all have to go in one jump, next summer, or could we taper it in over a 6-month or 12-month period? I think that's a lot of comment I've heard from business people. Another is the primary duty test. I don't think people understand, unless you're in California, how significant a 50% rule test would be. It would basically wipe out any kind of assistant manager. It would wipe out a lot of kind of people in that administrative exemption. Because if you have a 50% test, basically you have to do exempt duties 50% of the time, and currently under the current primary duty test, it's just that has to be your primary duty. So I think indicating and writing comments that if the salary is going up as high as they're proposing, that the primary duty test should stay the same is something that employers definitely want to happen. The worst thing that could happen is have this salary go up to $50,000 get doubled, and also have a percentage, certainly not a California 50%, but even a 25%, test in the primary duty is just going to make it that much harder, and it's probably going to substantially increase the amount of litigation we'd see. I've got a couple more slides here, but I also see some questions coming in, and I'm trying to be cognizant of our time. So let me real quickly go through these next two slides, and then Steve and I will try to answer some of your questions. One thing I think you do need to look at is the trickle-down effect. If you do try to increase some of your exempt managers to reach this 50%, are you going to have compression with some other managers who may be, making 55 or 60? And if you get too much compression, are you then going to have to raise the salaries of those managers maybe above the people you might have to bump up? I think that's something you've got to consider. Clearly, the minimum wage is going to go up in some fashion. The federal government always looks at what states are doing and is slow to react, but will eventually react. Whether it's $10, $12, or $15 an hour, I do think the minimum wage is going to go up. So that's, if nothing else, from a budgeting standpoint. And then I do think you need to think about how this is going to impact employees. A lot of people, when I give advice on exempt, non-exempt status, the whole status thing of having to clock in and do a time clock is real important to people. But if you're not going to pay them the minimum guaranteed salary, then you're going to have to make them non-exempt. And that's just something you're going to have to talk to your employees about. And I do think that, you do have an excuse, if you will, and, hey, the Department of Labor changed the rules on us, and this is what we got to do. So you could put a positive spin on it, or a spin at least that looks like it's something the Department of Labor has forced you to do as opposed to you just doing yourself. The other thing some employers may need to look at are their benefits. I'm not sure a lot of people are thinking about this. If you have managers who you have to reclassify as non-exempt and your benefits are better for exempt employees, you may need to amend your plans if you want to try to create some better benefits for what might be called a middle-tier management-type position that's classified as non-exempt simply because we can't afford to pay $50,000 a year to that position. So those are some other things that you might want to consider. I'm going to go ahead real quick now and look at some of the questions. And, Steve, if you read one and want to take it, go ahead.
Okay. Well, there was one question that asked about, you had mentioned that there are some special rules for teachers, for lawyers, for doctors, And so there was a question about nurses and social workers. Nurses and social workers don't fall under that special rule. There are special overtime rules with regard to nurses in certain facilities, known as the 8 and 80 rules. But in terms of whether a nurse or a social worker is going to fall within one of the executive, administrative, or professional exemptions for overtime, they're going to have to actually meet one of the 3 exemptions, meet the job duties test, and they will also need to meet the minimum salary requirement in order to qualify for an exemption. There was a similar question that said we've got a janitor who we pay a set salary as opposed to using contract labor. Can we still treat that person as exempt? The answer to that, unless that janitor has some sort of administrative or managerial responsibilities, for example, is the head of a department and is truly performing exempt work, the fact that you're simply paying him a salary does not make him exempt. He's got to be meeting both your job duty and your minimum salary requirements. So if you're paying a janitor a salary and you're covered by the Fair Labor Standards Act, then you're not meeting the proper requirements. And again, I think what you need to remember or think about is, so what that means is if that janitor is working overtime, then you should be paying overtime on top of the salary to the janitor. So that's what the requirement is that when you get into an overtime situation that you're paying him, and you also, because the janitor would be non-exempt, you also need to be sure that you're keeping appropriate records of the hours worked and the other requirements for a non-exempt employee. Chuck, do you want to take some of the other questions?
Yeah. Let me take 2 that are kind of companion from Kathy and Shelley. All right, first let me do Shelley's, which says 50% of our employees are outside sales. Outside sales currently does not have a salary basis test, and there's no indication in these regs that they're going to change that. So if they're truly performing outside sales, I mean, you can pay them straight commissions, you can pay them a draw on commissions, you can pay them however you want, but they've got to meet the outside sales primary duty test. The second companion question was, well, if we have a salary sales rep who's doing inside and outside sales work, and they're also doing a commission, will we have to now impact the base salary? The answer to that's going to depend. I mean, if they're doing inside and outside sales work, that could be a close call because the Department of Labor takes a position that inside sales work is never going to be exempt. Now, if they've got administrative functions, but they also do some outside sales, there are, opportunities depending on how you pay them to have an argument they meet the outside sales exemption, but if they don't, a fallback argument is the administrative exemption. However, the only way you can make that argument today is if you pay them a guaranteed salary that meets the 455, and then you can pay them commissions on top of that, and you have a fallback argument on the administrative exemption. When these salary amount increases, and if it goes to $50,000, let's say, if you don't pay them a $50,000 guaranteed salary plus commissions, you will lose the opportunity to have the administrative exemption as a fallback argument, which means if they don't meet the primary duty test as an outside sales, then that's going to be a non-exempt position. So I hope that helped clarify, but it's a good question. Outside sales are not impacted currently by these regs because you don't have to pay a guaranteed salary to an outside sales exemption. It's only the executive, administrative, and professional employees.
And Chuck, there's a follow-up question here. It says inside sales are never exempt, in other words. And as a general matter, that's correct. The Fair Labor Standards Act is probably one of the most, for lack of a better term, gerrymandered laws that's ever existed, and so there are all sorts of special rules in certain industries that may may result in an overtime exemption where you didn't necessarily know about one or didn't think there would be one there. So, for example, we had the person who was asking about agriculture. There are special rules in agriculture. We've got a question here about the automotive industry and commissioned employees there. That would be a separate rule that that would apply. And so in the issue of inside sales, the one area where we sometimes see an exception that exists is if you've got inside sales in retail establishments. There's a special rule that exists for people who are commissioned salespeople in a retail establishment where they receive more than 1.5% or more than half of their income comes from commissions, and their rate of pay is always more than 1.5 times the minimum wage when they work over 40 hours. And so there are some special rules out there for the for certain industries that I think it's important to look at before we say that something is absolutely one way or absolutely the other. There was another question too, Chuck, that probably would be a good one for you to address, which was how this applies to elected and appointed officials, because I know you do some work with public entities.
I do some work with some public entities, and I'll be honest, Steve, I didn't see anything in the proposed regs that specifically addressed that, to my knowledge.
I did not either, and I think it does certainly raise some serious concerns in terms of how this is going to impact public employers. The job duties requirements will be the same for public employers just as they are now. They'll be the same under the new regs if there's no change in the job duties tests. But then the whole minimum salary requirement could certainly raise some serious problems, concerns for public employers.
Absolutely, and I would expect some of those public employers to be providing comments, especially in smaller towns and smaller government. But like I said, I'm not aware of anything in the regulations that indicate that that would not be, that they would be excluded. But that's certainly something that public employers could write comments on and raise concerns about.
Okay. Let's see. Have we gotten to most of the questions, or what? Let's see if we've.
I think we have. I mean, some of them are more about a specific position currently at your location, and while I'd be glad to try to help you with it, I think it's a little outside the scope of where we are right now. But what I would say is that some of those, like Steve was talking about, the retail big ticket 7I exemptions, some of the automotive exemptions, there's some agricultural exemptions. There's nothing that I have seen in these regs that are going to impact those exemptions. If those exemptions have a separate, salary basis or pay scheme, then those would remain in place, like the Section 7I big ticket exemption. So I'm not aware of any change at this time, unless that particular exemption still requires you to be paid a guaranteed salary pursuant to Section 541. And if it did, then obviously it'd be impacted by these proposed regs.
Mm-hmm. And I think the other sort of a good general question that we received was asking us to expand on the duties test, and they're actually, taking a step back, these proposals are specifically focused on the executive, the administrative, and the professional exemptions. I mean, that's where they're really putting the emphasis on those three, where there is also a minimum salary requirement. And then for each of those, for the executive, for the administrative, and the professional, there are specific tests that discuss the duties for each. And I think maybe the best thing we could do, Chuck, would be to forward to people who want them some descriptions of what the job duties requirements are for each one, because they're very
Sure,
specific.
we could do that. Yeah, we could do that, or the Department of Labor on its website under the fact sheets has a good fact sheet for the primary duties for each of those exemptions.
Right, and that's fact sheet.
I'm getting some comments about how we've run over and people asking for some info, so I think I'm going to let Eric wrap us up, but you will see that if y'all have additional questions, you can email them to Eric and he can send them on to us, and we'll try to respond to you. But I want to thank everybody for your time today, and Eric, I'll turn it over to you.
Yeah, thanks, Chuck. Thanks, Steve. Really appreciate you guys coming on today. Great presentation, and thanks everyone for your questions as well. Those of you here for SHRM credit, go ahead and write down the event ID for this so you can get your credit. If you're on the phone, just email me at eric@hrsimple.com and I'll get that code for you. We're having a special offer for everyone here, which I'll talk more about in a bit. I wanted to get Steve and Chuck's contact info up on the screen. If you do have any questions, you can email them. You can email me. We'll send you a recording and slides from this webinar afterwards. We hope you'll join us for our next webinar, which is September 3rd at 2 p.m. I did see a quick question about HRCI credits. We are actually in the process of trying to get approved to give those credits, so hopefully soon we will be able to give you that as well. Like I said, we have a special offer for everyone here. Just go to hrsimple.com/August webinar. You can find out more about that. Okay, on behalf of hrsimple.com and Ogletree Deakins, thank you for spending time with us today, and we hope you'll continue to learn with us throughout the hrsimple.com webinar series.